Welcome to another episode of LERU Talks. My name is Katrien Maas. I'm Special Initiatives Ambassador for the League of European Research Universities and the moderator of the program. Today we turn to the topic of digital sovereignty. What does it mean? How does it matter? For universities as well as for tech companies. And to discuss this, we have two eminent experts. Mireille van Eekhout, Professor of Information Law at a LERU member, the University of Amsterdam. Welcome, Mireille.
Glad to be here.
And Alexandre Roer, Head of Policy and Deputy Head of Office of CCIA Europe, the Computer and Communications Industry Association. Alexander is standing in for Daniel Friedlander, who is at the last moment unable to make it due to a medical emergency. So thank you, Alex, for your willingness to stand in at the last notice.
Thank you very much for the invitation. Very glad to be here.
Great. After the interview, there will be time for questions from you, the audience. So you can submit your questions already via the YouTube chat function during the interview. We'll try to address as many questions as possible. So let's start with the first question about the concept of digital sovereignty. And I'll start with you, Mireille. Can you talk a little bit about that concept of digital sovereignty? What does it mean for you as a legal scholar? You and your team have done a lot of research on this, so please enlighten us.
Thanks. Yes, for our university, we conducted a study into digital sovereignty, broadly speaking, and what we arrived at is a definition basically that says it is for universities to have meaningful control over the infrastructures and the services and the data that they need to use in order to be able to do research and education.
Sorry. Yeah. Mm-hmm. Meaningful. What does that mean? Can you explain?
What it meaningful means, it doesn't mean that universities should all run their own infrastructures or all create their own services. You can go and procure services in the information markets because there's lots of things out there. But you need enough control to know what happens, for instance, to the data that is being created by students, by staff in education and research activities.
Mm-hmm. Okay. Can you give an example? Perhaps be a bit more specific about how this plays?
So in the education space, you can think, for instance, of electronic learning environments that universities increasingly have. Where students engage with each other and with study materials and teaching staff, and you can harvest a lot of data about what students are doing, and you want to make sure as a university that that data is only put to use for the benefit of the education and not that it's captured and sold to other companies. So you need to know what happens to the data.
Mm-hmm. Right. As public institutions, I imagine that's quite important, that aspect. But I wanted to ask about research. Can you give an example of how this pertains to research?
Yeah, similar in the research space where you see in the research cycle. So from designing research to actually doing it to writing about it and outreach. There are a lot of tools that are being used that also allow data being captured on what it is that research do, who collaborates with what they spend their time on, what networks they have. And also, if that type of data is captured, you want to make sure it's used for good purposes within research and not for just commercial purposes, for instance, because that's in the interest of the service provider who offers certain services.
Okay, yeah. So I think it's going to be clear that this is quite different for public institutions as universities as opposed to for companies. So let me turn to you, Alex. Digital sovereignty, when I say that to you and the companies that you represent, what does that mean?
To us, it means very different things depending on who we're talking to. I think ultimately policymakers, for example, in Paris, would have a certain understanding of digital sovereignty and what policies we're talking about here versus what folks in Helsinki or Prague may think what digital sovereignty is. I think if we look at countries in Central Eastern European countries, but also Belgium, Netherlands, Nordic countries, there's a distinct difference in terms. It's probably closer to what you're describing, Mireille, around user empowerment and control over our digital, everything that we do online, either as a university or as individuals.
Mm-hmm. Okay, Mireille, how does that resonate with you?
I think when you look at how universities engage with digital sovereignty, it's not so much about thinking in sort of economic blocks. And part of the discussion around digital sovereignty is about is Europe too reliant on American tech companies and technology companies? What is happening with the rise of China in this space? I think that's less of a concern to universities. It is on the level of information security and cybersecurity, but not so much when it comes to, let's say, economic blocks and how they relate to each other. I think digital sovereignty in some countries is also viewed more about promoting your own local industries, right? So,
yeah, I hear protectionism or not.
That's how some people call it. But
okay, let's move on to a next topic, and that is, I want to come back to something that you in your research, Mireille, have said about academic values. And you have argued that digital sovereignty is necessary to safeguard academic values in the digital age. Can you talk about that a little bit?
Yeah, so when we did the research, when we did the study, the team really looked at, okay, what is the role of universities, both in the education and in the research space, and what are the values that underpin those tasks. And then, of course, most broadly speaking, universities are about knowledge creation and sharing, and more for the common good and not so much for commercial or private interests, and to further scientific advancement. And in order to be able to do that, academic freedom is a really important value, which is also constitutionally protected in the EU. Both academic freedom at the level of the institutions and academic freedom for individuals and groups. And academic freedom also has two dimensions in terms of it being the freedom to engage in ask the type of research questions you want to ask, have the means to conduct research, or offer educational programs, and also the freedom of political interference, for instance, politicians telling you what you can and cannot research, or not having enough funding to actually fulfill your missions, or having private industry exercising undue influence over what gets researched or what happens to the research results.
Yeah, threats. Are these under threat? These academic values?
Difficult to say. I was thinking about this on the way here. In view of the recent political climate, for instance, in the Netherlands. If you look at the sort of language that's being used by certain parties that are now forming the Dutch government, they're very hostile towards universities and towards students. And I don't think they would qualm a lot in terms of limiting academic freedom. So I think it's academic freedom is not something to be complacent about. You know, even if it's the case that in the EU and certainly in member states like Germany, for instance, it's in the constitution, has been for a long time. The fact that we have these values and we say they are important doesn't necessarily mean they get respected and continue to be respected. So that's something to be really mindful of.
Yeah, it's certainly, if I talk for LERU, we have seen the rise of the importance of this issue, and also expect it to be more and more important, especially as we're going to have a new legislator with new commissioners, new parliament, and so on. Not to be underestimated. But let me turn to Alex. Does it resonate with you, these values? How do you see those?
Yeah, no, absolutely. I think, first of all, if we walk back just a second, I think in the history of mankind, it's hard to fathom what else other than the internet has propagated the free flow of information and knowledge across borders, across counties, across cities, and what have you, across universities. And I think whatever policies we put in place at European level, national level, it's important not to undermine, from our perspective, the fundamental principle of openness of the internet, whether it's because of the results of this or that specific companies in a particular market, or because we are seeing, frankly speaking, isolationist policies, the kind of which do not seem to correspond to Europe's long-held value of openness vis-à-vis at least its trade partners and its allies.
To me, it sounds as openness is also a value that we cherish at universities. Our collaborations are global. We want them to be global. But still, I can imagine, Mireille, that you would like to respond to some of the things that Alex said.
I think openness is one of those sort of wonder terms that sound like really positive, and we can talk, I think, all afternoon about pros and cons. I think, to be sure, for universities, traditionally, it has been very important to have all these networks, work across borders, for academics to work across borders. So that's really important to keep. And when it's about openness in terms of infrastructures, data and services, I think it's two-faced in a way. So basically it's a good thing. But to give the example of research data, if you were to open up, actually research publications is maybe even a better one. So we now have open access to research publications, is becoming much more the standard, which means outputs from research are available to everybody worldwide to use as they see fit. What we then also see is predatory open access journals that try to make use and sort of capitalize on this information. What you also see is that opening up research publications and data enables certain players that already have a powerful position in the market to capture even more data and translate it into services and data analytics, which they then sell back to the universities. So opening up doesn't mean that everybody has an equal chance, I think, in reality, to make use to benefit from research outputs or research data or software. Access is free at the point of use. You need to fund what it costs to create these publications somehow. Then if that means authors have to pay, then authors from certain universities can't afford to, which means their access to the publication space is limited. So there are trade-offs to, any type of model, I suppose.
Yeah. Okay, let me move on, unless you want to make another point, Alex. Yeah, because the next point I wanted to discuss is about the EU. As you know, as we all know, the EU has been quite busy legislating the digital transformation. Various directives and acts, the Digital Services Act, the Digital Markets Act, the Data Act, now the AI Act, etc. Alex, let me start with you. How are your companies looking at, how are they affected by this EU regulatory framework?
So how are they going to be affected? We will probably have a clear answer within 5 years or so. That's probably around the time where we actually see the effects of this or that, whether they're positive or negative, that we're seeing on the market. I think there is a huge challenge now to have all those 50 plus laws, if I counted correctly, that were adopted in the last 5 years, just focusing on tech. You mentioned a few flagship legislation, but there are obviously a lot more. There's a lot. We anticipate frictions. We are already spotting frictions, at least on paper. Inconsistencies, overlaps between this or that legislation. As industry we are looking for guidance. We are looking for predictability. That's not where we are now, but in the European Union's defense, we're only at the start of a long implementation, compliance, and enforcement journey.
Yeah. It makes some bells ring with me also in terms of what we as an association often ask of the EU institutions is that they coordinate their policies better. That sometimes the left hand doesn't know what the right hand is doing, and so you get these frictions and inconsistencies. I think that sounds familiar. Before I ask Mireille to respond, I'd like to remind our listeners, if you have questions, please put them in the chat via the YouTube channel. We'll be taking your questions at about 30 minutes past the hour, so after the end of the interview. So, but back to you, Mireille.
On legislation.
Yes.
So I share the concern about the complexity and the lack of predictability, what the impact is. This is also true for universities. And I think what you also see happening with universities, a lot of this legislation is basically about creating a digital single market. And it's very much about market thinking and the economy and about data as resource and data as a commodity, and universities are not accustomed yet, I think, to think in this way about legislation, so they find it hard to actually assess what impact does it have on us, to what extent does it cover the type of activities we're engaged in or not, and there is some uncertainty in all these different instruments as to that. I think it's a good thing that we see more attention for the position of research and universities in this landscape of so many different laws. But what is lacking is consistency and a more holistic view. And I think that circles back to what you said about sometimes the left hand doesn't know what the right hand is doing when it comes to lawmaking. But also, I think, to what you said, Alexander, about that there's legal uncertainty, but what the impact is and time will tell. But of course, that can make organizations very risk averse if they are uncertain about the impact, that they'll think, let's not do this.
Right.
In case it comes back to.
So maybe universities also need to be talking more to policymakers to see what they can expect or make their wishes and desiderata clear.
Yeah, sure. I think, and they've already started doing that. I think they've always been doing it, but not specifically on like data and digital legislation. So I think you already see that happening. I think it's also important that universities do more in terms of capacity building and sharing knowledge among each other. Because it's actually you need a sizable legal department to be able to tell what's going on with all this legislation. So it makes sense to sort of to really coordinate this and make it more of a joint effort.
Yeah, I'm reminded also of when there was the copyright issue that we actually asked for the exemption for universities, which was quite important. And we did get it. But that's just as an example, I want to say, of things where universities are usually not or a little bit disregarded in the bigger picture of this legislation that needs to come and be implemented. I think my question is also, how does this relate to digital sovereignty? Do we need to be doing that too? Do we need to ask for an exemption for something, so that universities will be considered, take into account what their needs are as public institutions?
I think, so if you want to ask for exemptions, you need to really know what your own need is. You need to be clear on that first. I think that's important. So I think if in the current legislative landscape, you already see that there are certain provisions, for instance, in the Data Governance Act speaks of data altruism organizations and tries to set up a system for that. That is potentially very useful because it offers universities a type of framework to engage in data altruism organizations, so they get they can collect more data for scientific research purposes. But it's sort of dotted around the legal landscape, so very hard to connect all the dots and to spot what the inconsistencies are. In terms of, do I think there should be a separate piece of legislation addressing universities? I'm not sure what would need to be in there, basically.
Yeah.
So you'd need to know really
Digital Universities Act.
Yeah, so what will be in it?
Right.
Other than things that are already or that should already be obvious around like academic freedom and so on.
Yeah. Does this also play in your association? Because I can imagine also that the needs of your various companies are quite different in terms of what they need in the digital legislation area and from the EU. Can you talk about that?
Yes, I mean, we are indeed looking, you said it very well, complexity is the name of the game at this point. Law firms, as much as it's an absolute bonanza for them right now, they also are sharing a sense of being overwhelmed. We're in beta mode at this point, all of us, including enforcement agencies, by the way, not just industries and outside counsel. We want provisions, legislation, whatever it is, we want them to be non-discriminatory generally, and we want them to be pragmatic.
Non-discriminatory, does that mean that no exemptions for universities?
No, in terms of like geographic locations.
Yeah.
Right, well, like where frankly speaking, for example, in the EU, I can use a concrete example. Universities are increasingly using cloud services. Now the European Union has been considering behind closed doors in rather sort of difficult discussions, technical discussions around limiting the use of cloud services that are actually based headquartered outside the European Union. In other words, what some would have wanted is a situation where in order for you to provide a secure, trusted and sovereign cloud in Europe, you would need to have your global headquarters in Europe. You would need to localize your data in Europe. You would need to have personnel who has access for technical maintenance in Europe. You would need to have to make sure that your owners or investors are European. So that's the this is the most extreme scenario. Fortunately, we only saw one. It's still being discussed. We are hopeful that this is going to be resolved. So that's what I mean by non-discrimination.
Okay, yeah, I understand. I saw Mireille, I think you may want to react to this.
Yes, I think so. When it's about, to the extent that these type of scenarios, so I'm not behind the closed door, so I don't know exactly what they're discussing, but they do sound protectionist, and they do sound to be also about market developments and the U.S. economy versus the Chinese economy, Indian economy. And perhaps also concerns around sensitive technologies and who gets access to them and how you can keep them secure. I think on the latter part, of course, universities like science departments and informatics departments and different types of disciplines are involved with research where there are concerns over security, information security. Mostly it's the universities who are being told by governments that they have to adhere to certain rules and processes and so on to guarantee information security. So to the extent that is also part of the discussion and part of coming up with solutions to enhance that information security, I think they're going to impact universities as well. Not sure that universities would be pro or con per se, as long as they can engage in their research, of course. I think that's an important thing for universities.
Okay, let's move on to a next question. Time is running, and we're having so much to say. We will, as you say, some things we could probably talk about for hours, but let's move on. The needs of universities vis-a-vis tech companies in this area, and specifically, we can distinguish between data and infrastructures, hardware, software. Is there something that you would like to ask of industry in terms of what do you think universities need? How could they be helpful?
Helpful. I think I fear that it's partly again in the field of legislation where you might look for answers. I think for universities, what's important in terms of to be able to be digitally sovereign, to have this effective control, that portability of data, cloud switching, all these type of things are really important for universities. If you zoom in more on, for instance, the research side, what you also see is that we live in such a digital sphere, all of us. And for academics, if they want to understand what's happening in our world, what is the impact of digital communications, of social media networks, and so on, you need to be able to study them.
Yeah.
But they're not observable, unless you're a user and you only see a bit of it. So another thing is access to data and transparency of, for instance, the workings of social media, of algorithms that are being used. That's really vital for academic communities to be able to actually understand what's happening in the world and to think along with solutions for the increasingly complex problems of our societies.
Yeah. Alex, can I ask you to respond to that?
Yeah, so first of all, on the point of transparency and researchers' access to data, I think here with new legislation, in particular the Digital Services Act, this is an incredible opportunity for researchers to actually get hold of data and be part of this implementation and enforcement phase that we're starting. The Digital Services Act in that respect is quite high level in terms of how vetted researchers should be, under which conditions they should be able to access data. As I said earlier, and I think as you said, we need a lot more specificity for researchers, but also for us. We are custodian of customers' data. As a researcher or any vetted researcher becomes suddenly a third party in that scenario. So we're going to need a number of different guarantees. You would think of in terms of, depending on how confidential the information or sensitive the information may be, researcher may have to go through. We would hope would have to go through a proportionate set of measures, technical, contractual, that. Just to make sure that the data that they obtain from the companies, whether that's commercial confidential information or personal data as well, to study the systemic risk that, for example, a very large online platform may create. We need to make sure that those studies, those measures are sufficiently adequate and verified. It's very important that the question is, at the end of the day, we don't want a Cambridge Analytica 2.0. I mean, I know this is a drastic scenario, but this is kind of what the thing that's sort of lurching in the back of our minds. And so this is very important to have verifications. Who's going to be responsible? Who's going to be liable if something goes wrong? Probably not a single researcher, but maybe probably the authority that should be in charge of vetting researchers in the first place. Things of that nature.
Okay. What does that?
I think the right to access under the Digital Services Act is one very specific one, where actually vetted researchers can get access to certain data under certain conditions. Not so much to do sort of free research on the questions they pose, but more as sort of agents in compliance, really, because they're only allowed to do research about systemic risks that certain platforms can pose. So your research is being instrumentalized in a way, which is, I think, not a trend, which should not become a trend. That's not something universities would be happy with. It's okay, you get access, but only to basically help for certain very particular objectives, because that doesn't really sit well with academic freedom. But no, I mean, it's obvious that companies who hold data have concerns about the security and safety of that data, and still we have to find ways to make to make that access meaningful and actually for academics to be able to do that research. I think in terms of access to research data, there's very little beyond the Digital Services Act. I mean, there's, I think, a clause, is it the Data Act or the Data Governance Act, about special emergencies where governments can get access to business data, and then also for some research purposes, but that's very limited, and the provision only applies in very exceptional circumstances anyway. So it is a larger question. If the digital spheres become so important, so pervasive in our societies, what is it that we need to be able to study it and its consequences? And, around disinformation is, for instance, a very, in elections, it's a very important topic. But you can also imagine around the climate crisis. And so there are many more huge societal challenges where you need to be able to have access to data in order to research it properly. So I think that's a topic that's going to stay with us, but it's also a question of, how can you articulate your needs as a research community, and how can you work with governments, with private sector to make it happen.
Well, we've been talking for half an hour almost. Time does fly. So it's about time that we have some audience questions. But before we do that, I just want to give you an opportunity to kind of say a final comment or a thing that you wanted to say early that hasn't come through that you want to say. Just give you the opportunity to do so before we take some questions. Anything? Alex, I see you're roaring to go.
No, just one thing in particular. I think when we talk about things like legal uncertainty and predictability and the need to get pragmatic, we're talking about real life consequences if that doesn't happen. I think it was 3 European research institutes that put out a report in 2021 around the cost, the real life costs of legal uncertainty to just transfer data over to the United States where their peers in the US. They estimated that around 5,000 joint European and US projects were suspended as a result of legal uncertainty. That was for 2019, so before we had a new adequacy decision with the United States. I actually still think that as a university, if, for example, a European researcher were to work with an American university or an American researcher affiliated with an American university, that university will probably not be certified under the Privacy Shield and would have to go through onerous obligations. They're kind of completely disproportionate at this point. And this is not because of what the GDPR says, but rather the interpretation of, for example, the data protection authorities in that space. This has real life consequences. We're talking about here 5,000 medical research projects, and that was before COVID.
Okay, I turn to Mireille.
Either
respond or make another.
Well, I think this is very GDPR specific. So, but maybe more broadly, just 2 or 3 points. I think one thing that's important is that the public interest role and mission of universities, both in research and education, are really sort of structurally taken on board when thinking about new legislation, so that the law doesn't even become more complex and unfathomable for universities and work against them. I think that's an important one. At the end of the day, it's really important that funding stays in place. I mean, in a sort of datafied society, if you look around AI, labor market shortages, are you able to attract the right staff to actually engage in meaningful research and education is also an important one in sort of in a digital age. I think those are 2 important ones. And also in terms of when you think about universities, also take academic freedom, both at its institutional level and at the individual level more seriously.
Yeah. All right. it is time for some audience questions. They've been coming in. Thank you for that. So I'll have here some questions that we're getting in. I'll turn to the first one. It's from Frans Oort from the University of Amsterdam, a colleague of yours. We know Frans also because thanks to Frans, we've been having some good discussions on digital sovereignty also and the public infrastructure needed for universities. And actually, that is the question. Do we need public infrastructure for publications, for research data, etc., to preserve universities' digital sovereignty?
I think
I'm looking to you, Mireille. But
no problem. No, I think to a degree we already have public infrastructure. If you look at some national levels and around, for instance, in Europe, what Jean is doing, so it's already there. Should it necessarily be infrastructures that are owned by public universities? I'm not so sure. I think you can have ways where you can actually you can rent server capabilities and you can have services as long as you have enough control over what happens. I think that's the more important thing. When it's about should we have infrastructures more in a way around research publications and outputs, I think the question is we have a very problematic academic publishing market at the minute with huge power concentrations that no university can sort of move around. I would hope that in the future, having more public infrastructures would sort of help address that. But that'll probably be only one of the ways.
Yeah, I actually saw another part of the question here by Frans that says, and I think that's for you, Alex, or can industry build the infrastructure that universities need? And how do we then safeguard digital sovereignty?
That's a interesting question. Again, it depends on who you ask that question. I think, well, first of all, tech companies do build already. There's a number of infrastructure also located in Europe, precisely to host any kind of customer data. Universities being one of them. And if indeed digital sovereignty is about control and solely about user control versus industrial policies and isolationist policies that the EU might have, or some in the EU might have entertained, then we fully subscribe to that. I mean, this is, if you look at, if you're procuring a cloud infrastructure or cloud software service, I mean, this is industry's practice to indeed have to give the keys over to the customer with a whole set of not just contractual but also technical ways of making sure that me as a supplier will not start fiddling or have access to your data. I may have access to your networks just for technical maintenance, this kind of things. But it is certainly not my job to start looking into whether into customers' data.
I guess this is true for like if you hire server capacity and around cloud services, but so it's not about sort of interference with data, but the larger question is also to what extent are universities actually have the power to switch providers? How easy is it? How high are the switching costs and so on? Do you get locked in because you get bundled services and so on? So I think in that area things can be improved quite a lot, because that's and I think also that's where the argument around we should have public infrastructures come from, because you would have more direct control, like in a for instance in the Netherlands, SurfNet is a joint initiative by the Dutch universities that offers certain IT services that are then controlled by the university, so much more directly, I think. But I think they can coexist. I don't think, if you look at the investment that's needed, also in terms of security, that certainly individual universities cannot afford to do it. Collective maybe, but I think it's always going to be a mix of industry and.
So is this financially a big burden on universities?
I think increasingly so with the capabilities you also need to keep information secure and cyber attacks and all these kind of problems. So at the very least, universities need to work together because for single universities it's really not feasible. But I think it's likely to be a mixture of private and more public.
Okay. Did you want to say anything else, Alex?
No, just to say I'm hopeful on the point of switching. I think I totally agree with you. I'm hopeful that we, as a result of the Data Act, we will see market practices, unfair market practices that essentially lock in users into one specific set of products provided by one single vendor. And allow indeed customers to adopt a multi-cloud strategy. Ultimately, it's about making sure that customers get to choose all available technologies that may be on the market. Hence the point about non-discrimination that I made earlier. But it's also about making sure that there's fair competition as well on the market, and it's about the customer choosing the technology that best suits their needs.
Okay, let's move on to another question. This one is by Sarah de Koster from the KU Leuven. And she says, related to Frans Oort's question, what is the role of legislation in digital sovereignty? Or do we rather need principles and guidelines? And what is the right level to create such guidelines? So we already have a lot of legislation. And the question is also, do we have too much legislation, maybe? I don't know. What's the right level of...
I think the legislation we currently have is not about digital sovereignty so much. I mean, maybe cloud switching in the Data Act, if it's really becoming effective. I mean, it's still there on paper. I think from the perspective of universities, I think it's much more important to first really agree, so what are the key ingredients of digital sovereignty? What does it mean for the way we procure services, for instance, for how we deal with our own research and educational activities, the IT departments, how are they run? So you get a better idea of what it is that is needed, and you decide to jointly act on it and hope you don't get into trouble with the competition authorities at some point, because that's another uncertainty, of course. Like, at what point are you engaging in economic activities and then attract that part of legislation?
Perhaps the question was mostly for universities, but Alex, did you want to add something?
No, I mean, nothing much to add. I think we have gone through, I think that the simple answer would be, we have already indeed a lot of legislation. If we're being realistic, in the next 5 years, we may, in the tech sector at least, anticipate more legislation, even though right now we're hearing a lot of voices saying, hang on a second, which rightfully so, and what does that mean for our companies in Europe? Those who want to export outside, those who want to be championed not just in one national market, but across the European Union, and more importantly, scaling out outside globally. We have some opportunities, some interesting new up-and-comers where in the field of AI, for instance, that are promising. Some of my members actually use European AI developers to make their own thing, and this is all happening across, globally. So, we've had a number of interactions with the European Commission, the European Parliament, the Council, and several times as we discuss this or that legislation, we are told that when we point out something that is not clear, we will figure it out, and that is not right. That is not right. We need more predictability. I think this is a key cornerstone, maybe a reminder for the next 5 years. This is essential to the rule of law. We need, it's also an economic principles as well. Businesses need guidance when the laws are rather drafted at abstract level, We need to be far more hands-on about what does that mean in scenario A, B, and C. And that can be indeed in the form of guidelines.
Yeah, clarity in implementation, guidelines. Yeah, okay. I saw you going.
Yeah, that can help, but I mean, it's also having to be realistic about what legislation can do, and to the extent that if you try to, if you see certain developments and you try to steer by regulation, you cannot always provide absolute legal certainty or predictability. So a certain level of uncertainty, I think, is always going to be there. But it's of course a good practice to try and limit that to a minimum. And then sometimes the legislative process doesn't really help in terms of like maybe last minute changes coming in or political arm wrestling going on, and then something happening like that. What just happened here?
Yeah.
May I jump in with a practical example? You talked about earlier about data portability, and the Data Act talks a lot about data portability, not just from an individual user's perspective, but also from a legal entity's perspective, like a university. And the Data Act is clearly focusing on IoT products, so moving your data, IoT products, so moving your data from one connected device to another. That can be industrial device.
Oh, the Internet of Things.
Yeah.
Yes. Sorry, Internet of Things. All well and good. It's actually building on the GDPR, and that's really a testament of you would think a provision that's, or a set of provisions that's about user empowerment, that's putting the user at the center. Except it does prohibit, it doesn't say quite like that, but that's the effect of a prohibition for gatekeepers, so 4 or 5 companies, to receive any data from any users, especially when users, even if the users want to move their data over to the services. In the university, maybe in industrial environments, it's a little bit tricky to imagine, but a very sort of maybe practical example as consumers, let's say, virtual assistants. If you wanted to move your data from one virtual assistant over to another, technically you are entitled to under the GDPR, but you're not allowed to under the Data Act. And that raises question of liability. Either I comply, if I'm receiving a data portability as a company, am I going to comply with the GDPR or for personal data, or am I going to comply with the Data Act? But I can't comply with both.
Really?
And so that's a space from, like, that's an example at the consumer level, but there are obviously instances, like we'll have to see how that works for the broader IoT products out there, including those used by researchers in engineering or what have you.
Yeah, I think in this example in the Data Act, you see the mechanics at work when they're trying to curb the power of certain companies by, making special rules around what gatekeepers can and cannot do. That is not necessarily consistent with earlier legislation we have. So I think for universities, that part of the Data Act is perhaps of less importance. But it shows the complexity of
Yeah, and again, the left
coherent
and right
framework.
sort of, having a coherent framework. Absolutely. Let me turn to another question. This one is: a new data business has emerged in the field of scholarly communication. We talked about it already a bit. Mining data of citations and downloads and processing these into what are called scholarly productivity, impact assessments and predictions of future research trends. These things are happening, are important to universities. So the question is, do universities have to fear that commercial companies will be in a position to influence the academic reward system? So how do researchers get promoted and hired on the basis of what decisions, of what assessment, and evaluative decision-making systems in the university? I think that's one for you, Mireille.
Okay, yeah. I think so. So
it also says,
so my immediate answer would be, no, of course it doesn't have to be a problem, because you can decide to buy these services or not. Having said that, I think what's really a good example to see how sort of unwittingly certain products or services develop and get actually a lot of influence is around journal impact factors. Journal impact factors are like a rating of a journal, saying how sort of popular is it, how much citations does it attract, and so on. That started off way back when as a tool for librarians to help them choose what subscription do I take out. And that has morphed into a system that's become, certainly in some disciplines, incredibly important for people. People only want to publish in journals with a high impact factor. So they start conducting their research in a way that's conducive to, making a chance to get published there. Then career decisions and evaluations get taken on the basis of what's the journal impact factor of your publications. And now we see the counter move, like that we should not use. It's been going on for quite a while, right? That we should not be using journal impact factors as an important source of evaluation, but it's sort of like an innocent helping service that over time has become very influential and steered a lot of behavior in academic communities. So to the extent that these type of metrics that are being collected on the back of open published research data and publications, no, on paper they should not necessarily have influence, but they might evolve into like the next journal impact factor. And then 20 years from now we say like,
you said
we should have paid attention
decide
along
not
the
to,
Yes.
but universities are also in competition with each other, and competition may dictate certain behavior.
Funders actually, so the way universities are also assessed by governments, which are important funders, is also on the basis of what is your output, how productive are you, so on. So sort of like the datafication and having metrics, like I guess in all walks of life, it's becoming easier to have more data points, and it's becoming very tempting to let the data then decide what research to fund, and then give a lot of direction also to what research gets done.
But the data is only as good as what you do with the data, the interpretation of it, the analysis.
Yes, and it's also, I think, in a way, but this is true for any metrics or performance indicators. They're always some sort of proxy for quality and relevance, right? So if they become too dominant, you tend to miss the point or really steer research and education only in certain directions and not having room for the really curiosity-driven or the maybe the weird, strange ideas out there that turn out to be really fruitful in the end, had they been given the chance to be pursued.
We are drifting a little bit into another topic, which we could spend another LERU Talks on. But let's go back to another question. The question, this is, I think, about copyright. If I read it well, it says the copyright issues apply to higher education institutions, both as publishers of data used for training AI models, as well as users of AI technologies trained on copyrighted materials. So what is your opinion on how copyright will be interpreted in relation to AI? And especially on how content can be transformed by generative AI. That seems to ring a bell with you, Mireille.
It does, but it's another week of conversations, I think. So there's a lot of debate in copyright now around text and data mining. So there are specific provisions in European copyright law which allow text and data mining for research purposes, which would include using materials, for instance, collect them as training data to develop large language models, for instance. And of course, universities as producers of content, if I may put this in a some say disrespectful way, you cannot say content, are also an important source. For instance, for materials, if you want to create AI models and you use like essays written by students or journal publications output that's available under Creative Commons licenses and free for anybody to use. I think more broadly in copyright, you see the discussion moving in a direction where the use of copyrighted materials as inputs is generally seen as something that's a restricted act under copyright, unless you can invoke like a text and data mining exception. There are more complicated questions around, particularly in generative AI, the outputs, to what extent, how do they relate to the inputs and the training data at some point? Should you see them as copies or derivative works? These are also quite complicated questions. And then questions around, like, if you generate an image or a text with the aid of AI, should it be copyrighted? Does it meet the current standards? And if it would, who'd actually own it? But these are really, this is in the middle of the copyright debate right now.
Yeah, open, outstanding questions that need to be addressed.
Yes, and I think, if we bring it back to digital sovereignty and access to data, then I think if you look at the computer science departments that are working on AI, I think if you talk to AI researchers, they all say it's important to have high quality data as input data and training data. So access to that type of data, like the large content collections, for instance, of whether it's music publishers or in the film industries or videos or something, is another of these topics. Like, okay, if we want to be able to do really good video generative AI models, we should have access to data that we really can't afford, as you know. That is what the researchers would say.
Yeah. Alex, do you want to respond, or how does this resonate with you?
I think it's a matter of implementation, what we already have, and making it work maybe to at a time when we talked about the copyright directive, we didn't have generative AI. It wasn't clearly as democratic as it is today. I think we are talking to our industry and are talking with the music industry, the movie industry, anyone who creates copyright materials, and we should probably also engage in more discussions with the academia on this. But we're looking at, and it's a set ultimately of technical and contractual sort of opt-out measures, and how do you make it happen in a way that is sufficiently user-friendly for the copyright holder. But I think what we have strikes the right balance on the legislative level, does strike the right balance between, on the one hand, safeguarding the protection of copyrighted materials without necessarily sort of stifling AI, the rollout of AI products, not just in Europe but across the world.
There's a saying such as good contracts make good friends.
Exactly, but opt-ins, we are sensing that opt-ins is not necessarily the way forward, even for copyright holders. Sort of reversing removing the TDM exemptions altogether. So let's see. That will be a question that the European Commission will have to answer in a few months' time.
Yeah. Yeah. We'll certainly have an interesting future coming up, which is also a way of saying we've come almost to the end of this interview. The hour is almost over, but I do want to ask you if there are any last key messages, thoughts that you would like to share with our audience today. Final. I can't leave without having said that.
I have one wish for the next 5 years, is that the Brussels effect is not about exporting rules, but exporting ideas, exporting products, European products. Far more about that, and I think a lot needs to be done in terms of, you talked about the single market, but I think we're still this is still an ideal. If anything, let's see what's going to happen on the implementation phase, but I'm looking at some of the legislation where the governance framework is very much national based, and there are some relative degree of coordination among enforcement authorities. But to us, that's not, if you truly believe in the single market, we ought to think enforcement ought to be centralized. Unless you're dealing with purely local cases. But that's not a reflex right now. Actually, the enforcement framework in most legislation, with a few exceptions, is an afterthought. This was quite visible in the last 5 years. Maybe the DSA is an exemption, for example, or the DMA. But the Data Act is a counterexample of that.
Okay. Last words go to you, Mireille.
Yeah, maybe not so much on legislation, if only to say that I think if you look at the really complex landscape, I think it's really important that the public interest mission of universities and research is taken on board much more in the coming years. Also, if it would get to elaborations or specifications and implementation of certain rules. And to have enough attention for the non-economic aspects. That's really important.
Yeah. You're saying in different words what sort of I wanted to say also. It's been really interesting to have both a university legal expert here and somebody representing tech companies, data and platform companies, because obviously, there's some distance also, and I'm wondering if I can wish for the next 5 years, looking at what will happen at the EU level, as we do in my organization, LERU, that we'll have more opportunities for dialogue between public and private entities, so that we can work together in some way, exchange views or whatever, see what each needs, and that we are both targeting the same targeting. We're not shooting bullets at them, but we're both targeting EU legislation, and that we can use that for better outcomes, I hope. So, that said, we will have to close this off. We have come to the end of this episode of LERU Talks. It's been a good discussion, useful insights on digital sovereignty. The concept clearly has different dimensions. The perspectives differ. Universities as public institutions, tech companies as private, market-driven entities. So on the one hand, the values of universities as public institutions need to be respected. On the other hand, business interests also need to be taken into account. Both are affected by EU laws in this area, differently though. But as I was just saying, discussions with different stakeholders are definitely useful and necessary. So I want to say many thanks, Mireille and Alex, for being here and sharing your views with us. And thanks also to the whole team here. Thank you also, our viewers, for being with us today. Don't hesitate to leave your comments via the LERU YouTube channel or LinkedIn or X. So, and hope to see you at the next LERU Talks.
This is so not